Welcome, everyone, to this Professional Development Hour presentation brought to you proudly by the Atlanta Metro chapter of the Georgia Society of Professional Engineers, an affiliate of the National Society of Professional Engineers. Before we begin, we'd like to let you know that any opinions presented tonight are solely the opinions of the presenter and not that of the Georgia Society of Professional Engineers, the National Society of Professional Engineers, or any other of its affiliates. We certainly hope you will enjoy tonight's presentation, so sit back and relax. And on with the show.
I'm going to try not to go on too long and try not to be totally boring. But this is a bit of an ethics lesson. I know some of you have heard about the terrible things that Chevron has done in the jungles of Ecuador and the $9 billion lawsuit. What you may not know is that I was kind of there at the start of this whole thing, and I think I have a little bit of a unique perspective. All right. Here's some background in the oil industry. Oil exists as in porous and semi-porous rocks, usually deep underground. As shown below, the oil exists with water as well, and with produced water is the formation which is pumped out with the oil. Generally, you have to pump at least 4 42-gallon barrels of oil and water to get 1 barrel of oil. But the ratios change as the wells get older. In extreme cases, you might have to pump 11 or 12 or sometimes as high as 15 barrels. Oily water mix is pumped through pipelines to separation stations where the oil is removed by simple sedimentation. And in some cases, the water is pumped back to an injection well for re-injection into the ground. Produced water has been in intimate contact with the oil and does contain dissolved and suspended oil. Part of this is because there is no really good separation. Many of you have heard of or used an API separator. That's what this was for. Well, in Texaco's case, the re-injection process was expensive. And between the early 1970s and the late 1990s, Texaco and Petroecuador, the 67% owner of the operations and the state-run oil company, discharged an estimated 17 billion gallons of produced water into the Amazon basin because of the expense. This setup saved the oil company between $1 and $3 per barrel of oil produced. Here is the basic formation in Ecuador. This area up in here is where the oil was found. This is the actual concession area. Quito is down, can't really tell right in here, but I think Quito, well, it stopped working. All right. Quito is down the center part of the state, and what you wind up doing is flying into Quito, and then you have another 2-hour flight back to Lago Agrio. Now, curiously enough, Lago Agrio in Spanish is Sour Lake, and it stands for Sour Lake, Texas, because there are a bunch of good old Texas boys who came down in the early 70s, late 60s and early 70s, and did the exploration for oil. I think the best way to characterize Lago Agrio, if any of you have ever been down either over in Europe or in South America, at the center of the town, what do you see? The iglesia, the church. In Lago Agrio, there's a monument to oil. And that just, it characterizes a whole lot about the area. All right, here's finer details of the concession. Lago Agrio is up here at the top, and the concession runs quite a ways. Agua, Conoco, Agruico, and so on. The little kind of gray line up at the top there that kind of bends and folds is actually the border with Colombia. So we're very close to the Colombian border. And regularly at night, you get out of the jungle because the FARC owns the jungle. And the FARC regularly comes in and they take steal oil from the pipelines and use that to help them refine cocaine. So you get out of the jungle after dark. Oops, wrong way. Now, I said earlier that this is a classic representation of what an oil trap and an oil exploration looks for. What you're looking for is the type of rock formations that bend and have this kind of downward curve and are impermeable. Oil collects there, and you have oil and water in this. Think of a sponge, because that's what most of this rock is. In some cases, it's not all nice and clean formations. That would be too easy. But take your basic sponge at home, pour some oil into it, soak it in water, and then try and extract the oil with a soda straw. That, in a nutshell, is your oil industry. It's got a lot of, you've got some producing zones, some other areas that are not, and then when you get down to the water, then it's water, but it's all been contaminated with oil. So all of the things that are volatile and dissolvable in oil, in water, are in the water. Here's a typical separation station. From the pumps, and that from the wells to the pumps, goes in, does some preliminary separation, and then they put it in. They do some separation in the major tank. Tank there, pump it back, and store it in tanks like this. So it's not a pretty operation. This is, let's say, 1960s, 1970s technology that's still in use today, depending upon various parts of the world. The tanks are not necessarily covered. All right, for a chronology, in 1969, Texaco went down to Ecuador and found oil. They started drilling in 1972, and Petroecuador, they partnered with Petroecuador, who owned a 5/8 share. 1973, in the U.S., by reference, we had the first Clean Water Act. So prior to 72, the only environmental laws in the United States were the Rivers and Harbors Act of 1896 or something like that, which said, don't dump your garbage off the ship. All right, 92, Texaco starts to turn over operations to Petroecuador and leave. They signed an agreement and to clean up 3/8, which was their share of the operations, and agreed to a $50 million remediation program. Also in 1995, there was a lawsuit on behalf of the Lago Agrio plaintiffs in the Southern District of New York in the U.S. The remediation, because it was some hundreds of sites, took a while, and it was finally completed by 1998. 1998, Ecuador approved the remediation and released Texaco from all liability. Well, in 2001, Texaco was purchased by Chevron, and Chevron then buys into the lawsuit. Due to a lot of legal wrangling and so on and so forth, 2003, the Lago Agrio plaintiffs' lawsuit was transferred to the circuit court in Lago Agrio, Ecuador. And this is the basic circuit court. We're talking a town of maybe normally 5,000 people, and you've got the local citizens suing a gigantic oil company. Talk about a circus. All right, facts on the ground. Texaco drilled 300 wells, and each well had about 2 drill pits. What's a drill pit? Well, in today's technology, what they usually do is they lay down a liner, a big liner, and they scoop out an area and lay this liner down, and everything that comes out of the well goes into the drill pit. Back in those days, there was no requirement to do that, and so they didn't. All right, Texaco drill pit technology used unlined drill pits, and that technique is still prevalent in the U.S. Only fairly recently have oil companies started to use liners in oil pits. Several of the oil-producing states do have a programs, like Texas and Oklahoma and some of those, have a program to clean up abandoned drill pits with revenue derived from taxes on the oil. Texaco discharged untreated produced water, and that's the stuff that after they separated in the separation stations, rather what they should have done is they should have taken the water and sent it, put in a pipeline to push it back down the well. They did not. It was cheaper to dump it in the Amazon. Okay. When Texaco left, they agreed to clean up 3/8 of the oil sites. That's 122 pits. They hired Woodward and Clyde and paid them about $50 million to clean up the sites to then current and now current RCRA standards. Now, there's an interesting thing there. Oil wastes are not regulated by RCRA. A Resource Conservation Recovery Act. That's Superfund, hazardous waste, and so on and so forth. Oil is not, by definition and by act of Congress, a hazardous waste. So it's not a regulated source. And the thing is that there's also a techniques, the analytical techniques for determining what is hazardous does not necessarily, the technique specifically, what they call the T-CLIP, or a toxicity characteristic leaching procedure that you run on to determine whether or not a waste is hazardous, is not necessarily good at finding oil. All right. The RCRA test also uses a dilution and extraction process, but the government of Ecuador signed off on the cleanup in '98 and released Texaco from all future requirements. Ecuador, after '98, Ecuador continued to operate the sites much as they were designed back in the '70s and '80s. Now, the toxic tour, recent photos from the toxic tour show current contamination sites which were not cleaned up by Texaco, and in fact they are totally operated by Ecuador. Some of you may have seen the movie called Crude. Anybody? Well, there was a movie about 4 or 5 years ago called Crude that purported to show the contamination of the Oriente by Texaco, but it wasn't. It's really Ecuador. All right, we're fast forwarding now to 2003 when the lawsuit was going on. In 2003, I went down to Ecuador and I was given a week to provide an estimate of what it might cost to clean up these 300 and some odd pits, less the 122, to U.S. standards, to clean up all the groundwater, to clean up all of the oil, clean up all the contamination, make it pure, pristine, and clean like it was. Well, I did. I came up with an initial cost estimate, very rough, of $6.114 billion. And it was based upon misleading information assumption that I was fed that the area would have to be cleaned up by Chevron Texaco. In fact, the whole thing was being operated by Ecuador. Big difference. Ecuador had negotiated a deal with the Lago Agrio plaintiffs. Says, well, you guys go sue the Yankees because they're the deep pocket. We don't want to spend the money. You go sue them. We'll split it with you. All right. The rough estimate was widely touted, and a campaign was set to try and force Chevron to settle, including pressure on the SEC, and there was actual testimony on the SEC, Congress, and massive publicity against Chevron, including working with Amazon Watch to promote the lies that were told. The trial in Ecuador was a circus. It was a literal circus. You have people in native dress. Some of the native tribes, the Hanori and the Kofan and all that, out there protesting against the trial against Chevron. You can see Texaco, Chevron, Texaco, remediation. Some of you are better at Atal Medio Ambiente. And it's clean up the environment, Texaco. Yeah, immediately, yeah. All right. A word about the trial. The trial is held under Napoleonic Code. And if any of you have had experience in Louisiana, you may know something about Napoleonic Code. Most of you don't, I'm guessing. Napoleonic Code is only practiced in Louisiana, thank God. It's almost totally backwards from what the way it's run down south of the border. It's run very backwards because they have the trial. The trial lasts, in this case it lasted 7 days total. Everybody takes the depositions and all that, but the depositions are taken in the judge's office. And let's say if I was almost a witness and they were prepping me to prepare testimony, and I was told that for every question that one side had, the opposing counsel could ask 3. This guarantees a rather speedy trial, but then after the trial is over, no decision is rendered. You then go out and then investigate the evidence, pull everything together, and then come back in, and the judge is going to make the decision. Well, because this was a circuit court, it was going to take a while. There was a very good likelihood, and actually it happened this way, that they went through about 3 or possibly 4 different judges because it was a circuit court. And so the initial judge that heard the testimony did not have a chance to see the final result. The other thing that's peculiar, and this is a throwback of pre-computer days, when they used to make statements and do transcripts in the court, they used to do it on lined paper. And they were very, very concerned about somebody crossing and changing the nature of the transcript of the testimony. So what they required was filled up. I don't care if you had only if your sentence was short and it only filled up half of the line, the next sentence would start right then. So you've got pages and pages of testimony that read like one gigantic paragraph. Here's the photos of some of the contamination that I first saw. And it looks pretty bad. I mean, you could toss a stone out into where the guy is standing there with the yellow shirt. You could toss a stone out there and you'd hear it go gloop. Not splash, gloop. There's a picture of one of the separation stations. There's a picture of a partial swamp, and you can see that it's kind of sticky and nasty looking. And it is all black. And it contrasts mightily with the jungle. Here's a close-up of the separation station. That's a flaring vent. Here is some of the contamination you can see just walking around. This was at Sasha 14. And in the middle of the jungle, you've got this pond. That's a stream coming out of one of the separation stations. And I don't know that you can see it, but there is a sheen on the top of that because, as I said earlier, the oil coming out of the separation stations has just gone through an API separator, and that the removal is not necessarily all that good. All right, moving down, occasionally you have spills and pipeline breaks. And here's a swamp. And we're wading through the swamp, and we took this photograph. You notice that it's black. It would be black anyhow, but you notice that it has a peculiar sheen of oil to it. That bright, shiny. All right, now going back, I said in the early part that the trial was set up in two parts. The trial is over, and then the next year, in 2004, we went down to do the field work for the investigation. I led the scientific team that was trying to find the contamination. All right, the original lawsuit, in the original lawsuit, the government of Ecuador and Petroecuador were named as plaintiffs for damages and cleanup. The complaint was revised to specify and specifically exclude the government of Ecuador and Petroecuador from the lawsuit and focus only on Chevron. There was a cancer study indicating a higher incidence of cancer among women from exposure to crude oil. That study has since been proven to be inaccurate, but it was widely touted. The judicial inspection was supposed to have 122 sites at the rate of 2 a week, but the Lago Agrio plaintiffs cut the process short after about 15 or 20. I was one of the original plaintiffs' experts. The other one was Chuck Kalmbacher, who's a certified industrial hygienist. And we attempted to warn the attorneys and the LAP that the scientific data did not support their case, because we weren't finding contamination of the type that they wanted. Specifically, if you're looking for things in a situation like that, you're not looking for asphalt. You're looking for benzene, you're looking for ethylbenzene, toluene, and xylene. These are the four most highly carcinogenic compounds. It's not that some of the others aren't, but as you move up the chemical table, the solubility gets less and less. So, all right, as we said flat out that they did not have the data that would support their case. As a result, the reports prepared by Kalmbacher, and he signed off on them because he spoke Spanish, a lot better Spanish than I did, were secretly rewritten with different conclusions, made up facts, and submitted to the Lago Agrio court without Kalmbacher's knowledge.
With his signature?
With his signature. And with my signature in one case. Yeah. All right, what we were looking for, and here's what we had. We had a portable chemical lab, not very sophisticated, mapping grade GPS. We had the support from an analytical laboratory, surveyor's level of rods, sweat, a lot of sweat, and a Geonyx EM31. Now, the Geonyx EM31 measures conductivity in the soils, and basically you've got this little device here that you're walking along, and every so often you click the little box there, and that creates a measurement. And then when you plot this out, I don't know whether it shows up as it shows up in the contours, but this area in here is the area where you have the oil, where it's the deepest. All right, or actually, looking at another area, this area in here is where the oil was the greatest. But basically, they're going after this thing with a very, very crude drill rig. It's those of you who work with the geologists and that, basically what they're doing is they're driving this thing down. It's a split spoon sampler, and this is nothing more than a tripod with a little motor and a rope and a pulley. And they just raise the drill, the hammer here up and drop it and keep on driving down. All right.
How deep did you have to go?
Not more than about 10 feet. So we were relatively shallow. 10 feet in many cases. In many cases, we'd find oil or oil products down 3 or 4. And okay, here's a conceptual model of a pond and a remedial pond. All right, at the top you've got this layer of oily sludge. You have contaminated water, and you have drilling muds. Now I should mention that given the time, some of the things that were in the drilling muds back in the 70s and 80s and even into the 90s, you could still use hexavalent chromium, and you also use barium sulfate. Hexavalent chromium is toxic, but it's a good passivator for metal, and the barium sulfate is used as a weighting agent to help hold the hole open, prevent collapse. But typically what would happen is the pond would look something like that, and they'd come in and supposedly clean it up, and then remove all the water, and then fill it in. Well, when we looked at this, what happened, this is surface, this is about 1.2 meters, and this is about 2 meters. And basically what happens is we're finding oil down in this region here. And you're finding the type of heavy oils that you saw that were on the surfaces here. I don't know how well you can discriminate the color on the photos, but there is some photos from the investigation. You can certainly tell on a split spoon sample where the oil starts. And if you look closely here, you can see some shiny stuff, black, down there, and that's free oil, which is down at the bottom of the lagoon. And this was pulled out of here. So you're actually getting the gray soil up here toward the top, and then this is the layer of heavily petroleum contaminated oil, and then down below that it's relatively clean. So that's what you have. But there's a problem. And maybe the produced water is not so bad, especially when it's diluted. And so what happens is, I said, benzene, ethylbenzene, toluene, and xylene are the 4 really rough contaminants. This little chart shows you some of the types of things that some types of the contaminants in the produced water. Oil and grease, as measured by the oil and grease test, 16 to about 200, medium of about 75. Suspended solids, between 3 and 51. Some phenols, some arsenic, some chromium, some cadmium, some lead, and some barium. And again, as the number of atoms in the hydrocarbons increase, the toxicity decreases markedly. Due to the corrupt nature of the proceedings, after Russell and Combacker left the case, and I said early on that results were forged. The current, let's see, and the current, there's still a seal on much of the data, and the unreliable nature of the Lago Agrio plaintiff's data. Fortunately, I happen to have some data that I can compare with the earlier studies. And here, for example, is Sacha 6, sampled 3 pits, 95 meters, 375 meters, and 168 square meters. Media present, debris, oil, water, soil, cleanup method, surfactant enhanced recovery. Basically what they're doing is they're taking a detergent and scrubbing this. So in some cases they're testing this always against looking for the presence of hazardous waste. And again, the testing is not necessarily all that good because of the test methods that were agreed upon. All right, reliable data on Texaco's cleanup of the pits, Texaco data and the original LAP data. And what we found was that were there some solids there? Yeah, some dissolved solids, some chlorine, and here by the way are the standards right here. Chlorine, sulfates, total suspended solids, COD, CAD, zinc, copper, chromium, phenols, fluorine, nickel, lead, and dissolved oxygen. Well, from some of the pits that I've shown, pH was 6.3. Temperature, whatever ambient happened to be. Fats, oil, and grease, one was at 190, but a couple of them are less than 5. TDS, the limit is 2,500, and 190, 1,200, 91. So it meets the requirements. Chlorine, or chloride, 56 ppm. SO4, 1 versus 1,200. TDS, or TSS, 1 at 1,540, so that one may need a little more work on it. Settlable solids, very, very low. COD, supposedly 80, 61, 23, and 650. CAD, chrome, nickel, zinc, all of those, just about all of them, except at Sacha 57, were within parameters for cleanup. Going a little further, there's some more data that just basically, I put this on because I have been accused of going from one side to the other, and I'm saying no, specifically, this was the actual data that we found. I'll leave that on there for a second. I don't know how well you can all see that, but range of data on sites from the US lab. Barium, 320 to 710. Cadmium, 1.4 to 2.5. Copper, 51 to 64. Nickel, 21, 22. Chromium, 41 to 64. And that varies for the various sites. Some of these are water sites. Some of these are soil. You notice that there's little or no phenanthrene. Whoops, did it again.
Could you sum it up and tell the significance of the numbers?
Yeah, basically what happens is most of the numbers there meet the requirements for leaving the soils intact, leaving the soils and the water intact.
That was from the 120 that they paid to have cleaned up?
That was, yeah, that's where what we were focused on.
So,
yeah.
And they did that for $50 million. But your estimate for the other 200 sites or so, $6 billion to clean up?
Yeah, and
why is there that big discrepancy?
okay, very good question. All right, the question was, if they cleaned up certain sites for $50 million, why was the cost estimate $6 billion? Because I was given a different charge. For one, number one, it was no longer in the 90s, and we are now in 2003, but that doesn't tell half the story. The actual number that I came up with on the estimate for cleaning up the pits, just the pits, was around $300 million. The rest of it was the assumptions that I was told to include, which also incorporated, I was told that there was a Class 5 rapids. How do you clean up a Class 5 rapids? And then the other thing is the swamps, several swamps, and acres and acres and acres of swamps. And how do you clean up the swamp without destroying it? And then there was infrastructure questions about, okay, how are we going to get all the equipment there? We're going to have to build new roads, we're going to have to build new bridges, and so on and so forth. So yeah, it explodes. And then the other question was, I didn't have any data about groundwater. It was totally out of, estimate it, tell us what you think it might cost. You saw the size of the area. And if you're going to have to pump and treat or just try and clean up that much groundwater, you're going to come up with some huge numbers. And that's where probably 4 billion of the 6 billion is. Maybe 5 billion of the 6 billion is in the assumptions regarding groundwater. Now it's curious because lots of people have challenged the cost estimate, but they haven't challenged the numbers which went into it. In other words, this is what the unit costs were, and the unit costs, as far as I'm concerned, are still solid and viable. It costs you so much every gallon of water or every cubic meter of water that you're going to treat is going to cost you so much money. All right, 2008. Well, we were well out of it by 2008. There's also supposed to be an independent experts global inspection of all the sites to provide a damage assessment and cost estimate. But the over-anxious lawyer for the Lago Agrio plaintiffs corrupted the process. They extorted and bribed one judge, Llanos, to get a specific person, Richard Cabrera, appointed as the global inspector and promised him a $500,000 payment. And they then turned around and wrote the judge's opinion. The LAP wrote the global inspector's report and paid Cabrera, they bribed Judge Llanos with the $500,000 and paid Cabrera $300,000 and then paid Stratus Consulting out of Denver almost $1 million to make up the data in the Cabrera report, and then turn around and then criticize their own report because it was too much in favor of Chevron. So the judge's 188-page opinion was written by the LAP, Lago Agrio plaintiffs, and resulted in an initial judgment of $16.8 billion. When the LAP criticized their own report, they inflated the damages to $27 billion. Then the government of Ecuador offered to cut the judgment to $19.5 billion if Chevron apologized for contaminating their region. The Ecuadorian Supreme Court reduced the verdict to $9.5 billion, and the government of Ecuador and the LAP attempted to collect the judgment in other countries because Chevron at this point did not have any assets left in Ecuador. The International Court in The Hague, Netherlands, has ruled that the original agreement releasing Texaco and Chevron from future liability was and is valid. Latest chronology. 2008, 2009, the Lago Agrio plaintiffs and their lawyer, Steve Donziger, financed the production of the movie Crude. The movie outtakes exposed some of the criminal enterprise and illegal activity. In 2011, Chevron initiated a RICO suit. RICO is Racketeering Influence Criminal Enterprise or Criminal Organization against Donziger et al. In 2013, just about a year ago, it went to trial. This year, 2014 in March, I think, the verdict against Donziger and the LAP finding fraud and corruption, ruling in Southern District Court of Federal New York, was 497 pages with over 1,000 footnotes, and it details the entire bribery, corruption, and extortion scheme. The judgment bars the U.S. members of the LAP from being able to collect any money from their activities. Also, it took down a major Washington, D.C. law firm. Now, other concerns. And we're going to pick up here on, we should be able to, those two Yeah, okay. Go ahead, play it. This is from Chevron, so it will be a bit in their favor, but I believe it to be reasonably factual.
Well, how did the evidence of the corruption not stay hidden?
What happened was the lead attorney, Steve Donziger, and you have to understand, let me back up for just a second. Number one, you have to, for a lawsuit of this type, it's very expensive, extremely expensive. The laboratory fees are going to eat you alive. In 6 months, I was, because we got in 2004, the last half of 2004, in 6 months, we ran through $1 million that was all reimbursed, but that was used to pay laboratory fees, to pay sampling crews, to pay hotel bills, and all that, just for the crew that was on the ground, and my expenses, and Chuck Kalmbach's expenses, and our upkeep, and so on and so forth. That did not include the lawyers' fees and other expenses. So this was a very expensive operation, because you can spend on a complete analysis, you can blow 15 grand very easily, just like that, on a single analysis. So go ahead.
For many years, plaintiffs' attorneys have misled the courts and the public about the case against Chevron in Ecuador. Their claims of a rainforest Chernobyl sounded possible to some, but they just weren't true. They like to claim that the $19 billion judgment against Chevron is based on overwhelming scientific evidence. But what's now been proved beyond a doubt by their own experts is that their so-called scientific evidence was completely fabricated by the plaintiffs themselves. One by one, the plaintiffs' own experts have testified under oath that when the scientific evidence didn't go their way, the plaintiffs simply made it up. Dr. Charles Kalmbacher was one of the first consultants hired by the plaintiffs in 2004 to perform scientific testing in an effort to prove contamination by hydrocarbons. When the tests found no such contamination, the plaintiffs and their lead U.S. lawyer, Stephen Donziger, drafted a fake report filled with fake findings and simply attached Kalmbacher's signature without his knowledge.
I did not reach this conclusion, and I did not write this report.
But Kalmbacher wasn't alone. David Russell, the lead scientist for the plaintiffs, also couldn't find any scientific evidence to support their claims. After several months investigating oil operations in Ecuador, he too concluded the environmental evidence did not and does not support the plaintiff's claim. Russell provided that testimony in an affidavit in 2013. He went on to say, "I had seen no evidence of any widespread contamination, and there was no evidence linking residents' health problems to Texaco operations. I am confident that the damages number in the judgment has no basis in fact." Donziger misled me. Based on all the scientific evidence I have seen, I am certain that Donziger and the plaintiffs are lying about the environmental conditions in Ecuador. But a lack of scientific evidence wasn't about to stop the plaintiffs in pursuit of their fraud, as Donziger was caught saying in outtakes from the movie Crude.
Facts do not exist. Facts are created.
In an effort to create even more facts, the plaintiffs hired Ann Maist and Doug Beltman of Stratus Consulting. They were charged with developing the scientific evidence to support the plaintiff's case. In April of this year, Stratus's Beltman and Maist not only admitted that they wrote parts of the damages report for Richard Cabrera, who was appointed by the court to serve as an independent expert, but also renounced all of the scientific findings and conclusions it contained, saying, "Stratus is not aware of any scientific evidence that people in the former concession area are drinking water contaminated with petroleum. At no time while working on the Ecuador project did I see any data supporting a finding of groundwater contamination." The plaintiff's lead science consultants went on to say, "I disavow any and all findings and conclusions in all of my reports and testimony on the Ecuador project. The plaintiff's own scientific experts agree. The judgment against Chevron in Ecuador is not based on science or fact.
Facts do not exist. Facts are created.
Unfortunately for the plaintiff's lawyers, facts do exist. And it's a fact that the plaintiff's case is a fraud without merit.
All right, next you're going to hear from Charles Kalmbacher, my good friend
Did you
Chuck.
at any time,
Go ahead.
while you were a plaintiff's expert in Lago Agrio, determine the volume of soil that needed to be remediated at any site?
No,
Did you ever determine what the cost of remediating soil at any of the sites would be?
no,
Did you ever find that any of the sites that you inspected had contamination of such an extent that it would endanger human health?
no,
Did you ever find that any of the sites that you inspected required any further remediation?
no.
While you were working as a judicial inspection expert for the plaintiffs, did you ever conclude that TexPet had failed to properly remediate one of the sites?
I didn't know.
While you were working as a judicial inspection expert for the plaintiffs, did you ever conclude that any particular site posed a risk to human health or the environment?
No.
Unable to obtain legitimate evidence to support their unfounded claims, the plaintiff's lawyers filed falsified reports with the Ecuadorian court in Charles Kalmbacher's name, claiming Dr. Kalmbacher found a cleanup costing millions needed to be conducted.
I did not reach this conclusion, and I did not write this report.
Experts for each of the parties were supposed to submit their reports for each judicial site inspection to the court. Any discrepancies between those reports were to be resolved by independent settling experts. At the beginning of the trial, the Ecuadorian court ordered the judicial inspection of 122 oil production sites. But as David Russell, the plaintiff's former lead environmental scientist, testified under penalty of perjury, in general, Donziger was unhappy with the data that the plaintiffs were finding during the judicial inspections and the cost of conducting the inspections. By late 2004, I realized that the plaintiffs could not prove their claims because the analytical data was turning up blank for both the soil and the water samples, and the samples were not showing the contamination that Donziger wanted. Unable to obtain real evidence, Donziger turned the judicial inspections into a choreographed show to further pressure Chevron Corporation.
I mean, this is all choreographed. These inspections, I'm convinced, have nothing to do with the trial at war. I mean, it's all about politics and arguing and bullshit and show.
When the settling experts issued their first and only report, finding that at Site Sacha 53, the risk to human health is low, and that the sample results were lower than the allowable limits, Donziger hatched a plan to abandon the remaining judicial inspections. Judge Yanez initially found there was no legal basis for the withdrawal of the judicial inspections. Donziger threatened to launch an all-out war with the judge if he did not accede to the plaintiff's lawyers' demands. The plaintiff's lawyers blackmailed Judge Yanez, threatened to file a complaint against him, and pressured him during illegal private meetings at hotels, restaurants, and Judge Yanez's home. Judge Yanez succumbed to the pressure, waiving the plaintiff's judicial inspections and permitting the appointment of a single global expert, Richard Cabrera, who the plaintiff's lawyers planned to secretly control. The plaintiff's lawyers could not risk the completion of the judicial inspection process, nor a truly independent global expert. Even their own paid experts were telling them that there was no evidence to support their claims.
All the reports are saying it's just at the pits and the stations and nothing has spread anywhere at all.
But hold on a second. You know, this is Ecuador. Okay. You say whatever you want. In the end of the day, there's 1,000 people around the courthouse, you're going to get what you want. We have enough to get money, to win.
One by one, the plaintiff's leading experts have come forward to disavow their work on the case. and to tell the truth about the plaintiff's scientifically bankrupt claims.
Turn the volume down a bit. All right, the last clip is 10 minutes long, and I won't play the entire thing. It goes on in a whole bunch of things, but they talk about the fraud, the corruption, and everything else involving Ecuador. The opinion, 497-page opinion, found that Donziger was guilty of fraud, bribery, and corruption, and is prohibited from receiving any profit from any judgment obtained by the Ecuadorian lawsuit. Decision is under appeal, be resolved probably early next year, but the attorneys are feeling pretty good about it. The judge's opinion reads as follows. In this case, the evidence at trial established that Donziger, a New York lawyer and resident, here formulated and conducted a scheme to victimize a U.S. company through a pattern of racketeering. That pattern included substantial conduct in the United States. Substantial conduct in the United States, e.g., the bulk of Donziger's overall supervision of the entire operation, much of Donziger's fundraising activity and ghostwriting activity of the Cabrera report, much of the pressure and lobbying campaign designed to injure Chevron's reputation and impact its bottom line and its stock price. A campaign micromanaged by Donziger that employed many U.S. public relations advisors and lobbyists. The making of Crude, a New York-based recruited filmmaker, and the improper efforts to ward off the discovery through U.S. courts of what really had taken place with Cabrera, Stratus, and the Lago Agrio plaintiffs. Absent the U.S. activity, there would have been no scheme. Even if there had been one, it would have been doomed to failure without that activity. The point is that Stratus came away with their reputation scarred, damaged. They lost their CEO and principal scientist, who had to disavow their own reports and say, yeah, we lied. Other people have been similarly wounded by this whole thing, and it's a great big shakedown. But Kalmbacher and I are still standing. And the takeaway lessons on this are, number one, seek to understand who you're working for and the scope of the case. I didn't have time, and that was my mistake. Tell the truth and keep to your area of expertise. I did that. Your professional reputation is all that you have, so guard it with care. Make your work transparent so that someone else can follow your train of thought, data, and calculations. Keep a copy of your notes and calculations away from the office and retain them for years and years and years. The last bit of advice comes to the U.S. military establishment. It says, a cadet will not cheat, steal, nor tolerate those who do. And that's not really a bad way to live. Thank you.
Who got the videos of Donziger on saying those things?
Oh, that was Donziger's the videos that you saw are from their outtakes of the movie Crude. And what happened was, at the point, and this was about 2008, 2009, the movie Crude was shot down there, and they started showing it around the U.S. as a fundraising activity. They made one small mistake. They had two different versions, one that contained some outtakes, and the other one which did not. So there was one version on YouTube, and there was another version in the video CD or DVD. And somebody at Chevron, Sarah McMillan at Chevron, noticed. And she went to the attorneys, and they said, oh, interesting. So they went into court and got the judge's permission, and they subpoenaed the filmmaker's outtakes. And what you saw there was a combination of the outtakes, where you have Donziger and Mace and all that sitting down there at the restaurant in Lago Agrio. And there's some actually much more graphic quotes of Donziger that appeared in the outtakes. Things like saying, well, it's the judge's right to be corrupt because they pay them so little. Not something I would really want to put on film.
So
but
he knew he was being filmed then? This was
oh yeah, he knew very well that he was being filmed, but he figured he could control it. Yeah.
With all those pictures you show, the swamps with all that gooey stuff, if it's not danger to human health, is there other danger?
Well, it kind of like it's like the closest I could guess is it's kind of like emulsified asphalt. I mean, if you can imagine we're using those in certain areas. We're using water emulsified asphalts, and yeah, they're there in the ponds, and they're there, and they just kind of sit there and do their own thing. But they aren't, unless you've got people drinking out of those ponds, they aren't really all that bad. Yeah.
Well, early on, you said you talked about the water that comes out as the natural course, and that over the years, 18
billion gallons got dumped into the Amazon.
And now the Amazon, I know that I've been told that dilution is the solution when you're talking
Exactly.
about solution. Amazon's a lot of water, but 18 billion gallons sounds like a lot. And so I'm wondering, just from the appearance that you created and showing the pictures of all that, these jungle swamps, it sounds like it creates the impression that there is environmental degradation, and it sounds like the plaintiff went way overboard, overreaching, but isn't there any middle ground that it sounds like the court's got to call a yes or a no, a winner and a loser. Is there no middle ground that says there was something that that it wasn't properly addressed?
Well, unfortunately, the trial which took place was not about science. And that's one of the first things that the judge said. This trial is not about science. This is about corruption. Now, the thing is there a problem down there? Sure there is. You can clean up one of those pits for around $150,000 to $200,000 per pit. But don't forget, you're dealing in Ecuador, where you do not have a particularly strong government, strong or caring government. Corruption is a way of life. And that area was at one time known as the Empty Lands because the natives did not speak Spanish. So there's I hesitate to say this, but there is an element of racism against the Indians and the native population by the folks who are in the big cities and so on and so forth. And there is contamination, but most of it is confined to the pits, and the fact that Petroecuador is operating a couple dozen separation stations, and that water is still going into the Amazon. Yeah.
It is refreshing to see you and Carmacker as experts who stood up for principles, so I commend you for that.
Thank you.
For what period of time did you and Carmacker work the plaintiff, and did you afterward get any engagements with the defendant?
No. Two things. Did I get any engagement with the defendants? No. As far as the I hired Chuck in early summer of 2004. I went down there first for the trial in 2003, and of course there's about a 8 or 9 month separation between the first trial in 2003 and the actual field work. So we went down, we set up our equipment, got all our equipment ordered, trained our people, and made sure that they were safe. And then in 2004 we went to the field. By late 2004, early 2005, we were essentially out of there. By December, we were out of there. And because I was naive and, you know, to me, it was a matter of fact. So I said, well, you know, hey, why can't I go to work for Ecuador, or for Chevron? They didn't want to come anywhere close to me. It wasn't because I didn't ask, but they said, you're contaminated. So because I had worked for them, there was a presumption that I was changing sides or whatever, and the attorneys and everything else have a different set of concepts about what you do. If you work for one side, you're contaminated. You can't work for the other side.
In retrospect, that looks like a good way to go.
It may have been. It may have been. I didn't appreciate it at the time. I do now.
For the benefit of the students here, I pulled up a website. It's the NSPE organization, Resources Ethics, Code of Ethics. And it has 6 fundamental principles. 1, hold paramount safety, health, and welfare of the public. 2, perform services only in your area of confidence.
Thank you.
3, issue public statements only in an objective and truthful manner.
Thank you.
4, act for each employer or client as a faithful agent or trustee. 5, avoid deceptive acts. 6, conduct themselves honorably, responsibly, ethically, and lawfully to enhance the honor and reputation and usefulness of the profession. I've also seen a code of ethics for engineers. Professional engineers will engage only in lawful, honest endeavors.
Thank you, sir. I would. Let me get to one point, and I'll get right back to you. You saw that I came up with a $6 billion cost estimate. I think you are all familiar, or most of you are all familiar, with the term swag, and you know what it means. I introduced that into federal court last year at this time. In characterizing my own estimates. And the judge kind of looked at me and said, He said, we've got a lot of that going on around here. But the point was that when I began to see that this very, very rough cost estimate, and again, I was down there I had about 4 days in the jungle, going on what was called the toxic tour, and told to sit down by myself and come up with the numbers. And it was my best guess. And then they started to use that as a club to beat Chevron over the head to try and get them to settle. And I found that deeply morally objectionable. And I warned them time after time, stop it. Matter of fact, I'm on record in the court documents as saying cease and desist. Stop using the estimates. They are not functional. They're not accurate. They're not they're not serving your purpose. But all these guys could see was dollar signs. Let me catch this one first, and then I'll get back to you. Yes? It might have been sustainable, but okay. When you have a lawsuit of this type that is very, very expensive, there was one of the partners, Cohn Swift, a law firm out of Philadelphia that was a public interest law firm, and they got in other people, a Washington law firm, that is now, they had to pay a $15 million fine for their participation. And this guy who does pioneered internet gambling. He's over in England somewhere, off the offshore Isle of Wight or something offshore. And so they were all participating in financing or funding the lawsuit in hopes of getting a portion of the profits. And I should also mention that it came to light that if they ever do get any judgments where they can collect, all those profits will go into a special drawing account offshore, not available to either the government of Ecuador or the Lago Agrio plaintiffs. The people who are going to get paid first are the people who participated in the lawsuit and filed the lawsuits. And so the attorneys and all that are taken care of, and the financiers are taking care of themselves. Yes?
I was going to ask, with the benefit of hindsight, your $6 billion, that estimate you created,
Yeah, $6 billion.
Would you, knowing what you know now, having lived through this, would you not render any kind of judgment like that in the future?
I would have insisted on going in and doing some sampling. I would have insisted. I should have insisted.
Deliver a number based on such crude estimates under a professional. Would that be your advice?
Yeah, and basically, you have to I got led. I felt I got led like a lamb to the slaughter, because I walked into this. I thought my eyes were open, but I didn't realize that the other half of the case was hidden, and that how this cost estimate was going to be used, nor the scope and the conditions and so on and so forth under the cost estimate. I had no clue. And the politics that were involving around this thing were just incredible. So yeah, I would, if I had to do it over again, I would insist that either they get somebody else or allow me to go do sampling and start to do some things right. But I didn't even have so much as a test kit. So,
time for one more question.
Okay. Go ahead.
So, originally, your participation in this began in the late 90s.
No, my participation began in probably about June of 2003.
2003, okay. And obviously, the whole story is about fraud and deception. Could it happen today? I'm just with instantaneous communication that we have, and even in the remotest
Absolutely.
world, I mean,
absolutely, it could happen. I mean, 2003. Don't forget that video clip was 2008, 2009, and the communications aren't all that different. Matter of fact, they've improved a little bit, but sure they can. And this was a massive publicity campaign, and people were persuaded. I mean, for example, Trudy Schuyler, Sting's wife, was paid something like $50,000 to go down and lend her name to the go down there, clean up, and get on the website and other places to scream about the contamination, to try and put pressure on Chevron to settle. This was all about trying to get Chevron to settle.
All right.
Okay?
David, thank you very much.
Thank you all.
We hope you enjoyed this presentation given at one of the Atlanta Metro Chapter meetings of the Georgia Society of Professional Engineers, an affiliate of the National Society of Professional Engineers. To find out more about us or to join us, check us out at gspe.org.